Welcome to Dad's Divorce. Today we have with us Richard Coffee, who is the senior attorney in our Belleville office. Richard, thanks for taking time with us out of your busy schedule to talk about this article that you wrote.
Always happy to help inform our audience.
And the article is entitled Strategies to Address Potential Relocation Efforts. And if you could just kind of, when I was reading through the article, there's some points in here that help people out when they're dealing with a potential relocation. And one of the issues that kind of stands out that a lot of people, at least from my experience in dealing with clients that come through here, and especially some of the emails that we get from the internet when people go on DadsDivorce.com and submit under Ask a Lawyer question is, can this be an expensive and lengthy process to challenge any relocation? And the short answer is yes.
Well, that's true of any contested custody matter, I'd say.
Right.
Children being the party's most valuable asset, if you will, they certainly don't want to forego any option to make sure that what's best for their children and hopefully for themselves is accomplished, and that can be very expensive, as you pointed out. And relocation is one of the more expensive processes that we have, certainly in Illinois, and from my discussions with colleagues, probably most jurisdictions, because it involves a lot of variables and a lot more speculation than perhaps the original custody debate involved.
Right, and then a lot of times people, once the decree is entered by the court, a lot of times people are under the false presumption that that's going to be what the residence is from that point moving forward, and a lot of times that's not the case.
Well, absolutely. People, when they come in to talk to us, she can't do that, can she? Well, let's take a look at your judgment or your decree and see what it says about it. It's something that is often not considered, particularly where the parties during the marriage were looking at this community as being where they were going to raise their kids, and now that they're no longer partners, the possibility that someone wants to find a different community is alien to them, and understandably so. So when we go through the relocation issues, it gets very complicated, and a lot of emotions are involved, and that also helps drive up the time and necessarily the expense of the process.
Exactly. And we've had some emails come through on the Ask a Lawyer and some of the clients that come through, and the general question is, who has the burden in this case when you're dealing with relocation? Is it the parent who wants to relocate, or is it the parent who is objecting to the relocation?
Well, that's going to depend upon the specifics of your jurisdiction. The ones that I'm familiar with, the burden is on the person wanting to make the move. Now, we've also had situations where in the original divorce, the father usually was either not represented or represented by someone that wasn't well-versed in this issue and agreed in the divorce that the mother could relocate at any future point that she wants to, or acknowledge that the mother's job may make her move somewhere else, and they've waived their argument. Now, in most jurisdictions, the judge is only going to give that some credence because the best interest of the child is, of course, the overarching consideration for the court. So when the burden is on the father, the non-moving party, then that's a different situation. But normally it's on the party that wants to change the status quo, as in most legal proceedings, is the one with the burden.
Now, if mom decides that she wants to relocate out of the state, what would be the proper way for her to notify dad?
Well, again, that's going to depend upon the requirements of your jurisdiction and any agreements that the parties may have made in the course of their divorce judgment. But what we find, the practical response, is that they just call them up, email them, or tell them over some family function that this could be happening in the future and that they may have to consider taking a job or moving elsewhere, and then they consider that enough notice. And I think most jurisdictions and most divorce judgments are going to require something a little more formal, and certainly if it goes before a judge, all of the details of the proposed move would have to be fleshed out. The timetable, the exact location, the exact rationale for the move, not the more general, oh, by the way, I may have to move, and I'm sure it won't be a problem kind of approach that most moving parents want to take, because they don't want to engage in a controversy over the move. They're usually moving because of a loss of a job or some new relationship, and they don't want to get into the debate about the underlying cause. So it can be a complicated scenario as to how the non-moving parent got notified, but most jurisdictions are going to require a formal motion be filed to get court permission to either modify the judgment or remove the child, whatever the mechanism in that particular jurisdiction might be.
Now, you raise an interesting point that you brought up, is a lot of times people come in and say, well, my ex-wife said that she may be moving or she may not be moving. Is that a proper time to seek judicial intervention, file a motion with the court that you were talking about?
Well, in Illinois, there is a specific provision to allow seeking an injunction to prevent the parent from removing the children from the state on a permanent basis. I would think most jurisdictions in their general injunctive law or their general temporary relief in domestic relations cases would have some method to get the issue before the court. Now, the response to that may simply be from the mother, oh no, I'm not moving. And that ends that discussion. And then a month later she's moving again. So it's not a guarantee that the issue will get addressed by a court, because the mother can simply say, no, I've changed my mind, or he misunderstood me, I'm not moving, and your motion for an injunction is going to be denied because there's no issue anymore. So it's one way to get the issue out there and get a formal response on the record from the mother, which you can then use down the road if she changes her mind again, to point out that just 2 months ago she said she wasn't moving, now all of a sudden she is. What's going on here, and is this really best for the child?
Now, for the individuals who are just tuning in or who are clicking on our website on the icon to listen to this, you used a legal term of art, which was injunctive relief. Could you just briefly explain what an injunctive relief would be?
Well, in this case, it would be to obtain a court order to prevent the moving parent from removing the children from the state until the court can enter a final ruling after a full trial as to what's in the best interest of the child. As I'm sure many of our listeners are aware, injunctions are used all the time to stop people from doing things until a court can rule on it. And again, Illinois specifically addresses that on this issue. Most states are going to have a general catch-all provision for injunctions when such matters are at issue. So you would again need to contact and consult with an attorney in the appropriate jurisdiction as to the proper method, but in most cases it's going to be some kind of injunctive relief.
Sure. Now, a lot of times people ask, now, is this something that I can do on my own, or is this something that I need to hire a lawyer for? And what I'm referencing would be specifically this injunctive relief. Is this something that, in the state of Illinois, the jurisdiction that you practice in, is this something that a client can go to the clerk and get a form or get some type of help in filling out the paperwork and file it with the court themselves? Or is it better advised for them to seek professional advice and hire a lawyer to do this for them?
Well, of course, anyone can petition the court on their own if they wish, and that's certainly their right. But when you've got your children's future at risk and the technicalities of a fairly complex legal issue such as removal and best interests of the child, my opinion, of course, is that the client is best served by having an advocate who has experience in this area. And so, while yes, they could just ask the court to not let her do it, the judge is constrained by the law, and if the, as we call them, pro se or on their own litigants don't know enough or don't have all the right citations and information to give the judge is under no technical obligation to do the research for them, and they're a distinct disadvantage in that case.
Now, what if you have a circumstance in which mom moves with the children out of the area, not necessarily out of state, but just out of the area without dad's consent? What would dad's remedy be in that particular circumstance?
And that's part of the point of the article, is to prepare in advance in the divorce or in some modification proceeding for that possibility by building in agreements between the parties as part of the court order